of 64 small fishes established in 20. The green connection, that are the second and third applicants, are both non-profit organizations whose objects are to the members of whose livelihoods and their families have done. This community, the papers show, have borne the brunt of discrimination over the years, first under apartheid, where fishing quotas were fishing rights became hotly contested and were mostly available to commercial fisheries and to those who could afford to pay application fees. That is all contained in the founding affidavit, record page 9. Now, eventually in 2012, small fishers were able to obtain some recognition of traditional fishing rights following the adoption of the policy for small-scale fishery sector in South Africa. We realized during the preparation of the heads of argument, my lady, that although all of the parties had referred to the policy, no one had attached it. I'm not sure if your lady would like one, but I've provided copies to my...
Thank you.
This policy is important because it reflects the outcome of years of activism and advocacy around the rights of small-scale fishers, and it ultimately formed the basis of amendments to the Marine Living Resources Act in 2014. And while this has been a positive step, West Coast fishers have continued to be marginalized by commercial fishing and by the development of other industries along our coast. And that you'll find at record page 10, paragraph 11 of the founding affidavit. So I say all of this by way of context to this review. The applicants have approached this court for a finding that the decisions of the DG and the Minister are flawed and that they stand to be reviewed and set aside as a result. Now, contrary to what the respondents allege, we are not asking this court to decide a further appeal against the Minister's decision. We are not asking this court to step into the shoes of the decision maker and make what is a very technically and multifaceted, complex decision. We're not doing that. We're not asking this court to do anything beyond which happens daily in our courts, and that is to ensure accountable and transparent government, lawful and procedurally fair administrative action, and good governance. And those are the words contained in the preamble to PAJA, and they are the basis for this review. So although the respondents' papers are replete with suggestions that the applicants come to this court for a different purpose, I wish to just stress that the purpose of the applicants' come here is to assert their rights to fair administrative action. In my submissions today, I intend to deal with the following issues in turn. First, I'll provide an overview of the applicant's case. Second, I'll deal with the legislative context in which these decisions take place and go through what was needed to have been before the decision maker at each step. Third, I take the court through each of the applicant's grounds of review and show why the decisions we submit are fatally flawed. And then fourth, I'll deal to the extent necessary with certain ancillary arguments that have arisen in the respondents' heads of argument before concluding. Now, the papers in this matter are voluminous, my lady. You know this. I'm afraid I came into the matter after the bulk of the papers had been filed, and I must apologize that in crafting these heads I sought to simplify things and may have caused some measure of confusion for my learned friends for the court. That was not intentional. It was an effort to simplify the case and to group the grounds of appeal in a way that's manageable for the court to deal with. I'm pleased that the respondents' heads of argument seem to have dealt with all of the grounds that we raised, and so perhaps there wasn't as much confusion as I suggest. Now, the affidavits, just to be clear, the affidavits raise 10 grounds of review. In our heads of argument, we have abandoned 2 grounds, and we've grouped the remainder into 5 areas, which I'll take your ladyship through. So the only grounds of review abandoned on the papers at the point of the heads of argument are 7, which is the absence of a locality plan. I will deal with our first round of review and explain to the court why we, as of this morning, no longer persist in the delegation ground. But I'll take the court through that in due course. So the way in which we attempted to structure the heads was really to look at what was before the decision maker, whether that was sufficient, whether the reliance on PASA, as the minister did, was appropriate and lawful, and then whether the minister failed to take into account a series of relevant information, including the factors in IGMA, the unbalanced need and desirability assessment, defective EMPR, insufficient information on marine impacts, and insufficient information on cumulative impacts. And that's where I suggest, where I say we've grouped the grounds together under the ground. And then the final ground is looking at whether it was permissible that the environmental authorization was granted, that it contained conditions of approval requiring 2 further plans to be submitted after the environmental authorization was granted, meaning that those plans would not be subject to public participation. I'll deal with each of those in turn. Now, if one is to accept the respondents' arguments, then their impugned decisions are perfectly reasonable ones, which take all relevant considerations into account and which were procedurally sound. And if one accepts the respondents' arguments, then the applicants are simply litigious and opposed to any development whatsoever. But it's notable that it's not just the applicants that have raised concerns with environmental authorization in particular. It's notable that the papers show that in fact the Western Cape Department of Environmental Affairs itself sought to appeal the environmental authorization decision. And the grounds on which it did so, which are contained in the papers, are as follows. It asserted that cumulative impacts were not assessed, that there was a lack of scientific knowledge to gauge the impact of seismic acoustic blasts and their effect on the marine environment, and that the activities that had been approved, or the activities had been approved in the absence of a strategic environmental assessment. That's notable. It's notable and it's important that the Western Cape Department of the Environment itself thought the DG's decision sufficiently concerning to warrant an appeal. Be that as it may, the relief sought by the applicants mirrors some of those concerns and is not, as the respondents suggest, without any legal merit or basis. Now, my lady, the heads of argument take the court through in some measure of detail the legislative framework. And the legislative framework in this matter is critical because many of the grounds of review relate to what ought to have been complied with and done by the DG and the minister at each stage of the proceedings, and which we say is not done. So I'd like to move on to my next topic, which is the legal framework. I'm not going to do it in as much detail as contained in the heads of argument, and I'll take what has access to that as necessary, and when we deal with each of the review grounds, we'll go to the different provisions as required. But the first overarching and important principle is we submit that this review happens in the context of the Constitution and of Section 24 of the Constitution. And that must be the starting point of any assessment of the conduct of the decision makers in this case. Section 24 of the Constitution provides that everyone has the right to an environment that is not harmful to their health or well-being, and to have the environment protected for the benefit of present and future generations through reasonable legislative and other measures that prevent pollution and ecological degradation, promote conservation, and secure ecologically sustainable development and use of natural resources while promoting justifiable economic and social development. Now that's a mouthful, but critically, the important component of Section 24 is that it provides that there must be a measure of balance between protecting the environment, ensuring conservation, and preventing pollution and degradation of the environment, all of that to be balanced with the need for sustainable, ecologically sustainable development. That delicate balance that we submit must be drawn was recognized by the Constitutional Court in few retailers and cause little to no impact in our seas. But that is not true, and I'll take the court to it. We have set out in our heads of parliament exactly what is involved in a seismic survey. So we say, in making a decision to authorize something as drastic as seismic surveys, which is also something that is likely to lead to more invasive and further measures, such as exploration and production, that the department, which is tasked by the Constitution with protecting the environment, must give due consideration to all relevant factors so that it maintains the delicate balance that the Constitutional Court talks about. And in this case, we submit this has simply not been done. It gives effect to Section 24, and it provides a set of principles to be applied throughout the Republic by organs of state when taking decisions which, quote, may significantly affect the environment. It also prescribes a number of relevant considerations that must be taken into account when sustainable development is considered as part of integrated environmental management, and it sets out a series of principles in Chapter 5 of NEMA and in the Environmental Impact Assessment Regulations of 2014. That's referred to as the EIA regulations. Now, in particular, in addition to all other listed principles, Section 2.4, small subsection 7 of NEMA provides as follows, quote, that a risk-averse and cautious approach is applied, which takes into account the limits of current knowledge about the consequences of decisions and actions. That, your ladyship will hear throughout the arguments in this matter as the precautionary approach. That's reflected in Section 2.4 of NEMA. Then Section 2.4 small letter n of NEMA provides as follows, quote, global and international responsibilities relating to the environment must be discharged in the national interest. And Section 2.4 small letter o of NEMA provides as follows, the environment is held in public trust for the people. The beneficial use of environmental resources must serve the public interest, and the environment must be protected as the people's common heritage. So NEMA recognizes the balance that I referred to in Section 24 of the Constitution, and importantly, it recognizes the role of the South African public, of our communities, in being part of decision-making under NEMA. This matter deals with an environmental authorization, and that takes us to Section 24.2 of NEMA, in terms of which the Minister may identify activities that may not commence without an environmental approval. The activity of relevance to this review is an activity which requires a reconnaissance permit in terms of Section 74 of the Mineral and Petroleum Resources Development Act. You just bear with me, my lady, take some water. So a listed activity may not be commenced until and unless environmental approval from the competent authority has been sought and obtained. In the case of mineral and petroleum activities, the competent minister is the minister responsible for mineral resources. And the procedure for applications for environmental authorizations is governed by the EIA regulations. An application for environmental authorization is made to the competent authority in terms of Chapter 5 of NEMA and Chapter 4 of the Environmental Impact Assessment EIA regulations. And NEMA and the EIA regulation sets out a series of issues that need to be considered by the competent authority in their exercise of their discretion. And it lists multiple principles and factors which must be taken into account. And those include the principles of environmental management in Section 2 of NEMA, general objectives of integrated environmental management in Section 23 of NEMA, certain minimum requirements in Section 24.4 of NEMA, and the criteria in Section 24.0 of NEMA and in Regulation 18 of the EIA regulations. So NEMA enumerates these principles, and of importance is that Section 2 of NEMA says that a key principle of environmental management is, quote, to place people and their needs at the forefront of its concern and to serve their physical, psychological, developmental, cultural, and social interests equitably. Your ladyship will find that in Section 2, sub 2 of NEMA. So when development is pursued, which serves the needs of people, it must take place in a manner that's socially, environmentally, and economically sustainable. In other words, it must be sustainable development, and your ladyship will find that in Section 2, sub 3 of NEMA. There are a series of other principles that I won't take the court through, but they are listed in our heads, and they relate broadly to broadly to the balance that Section 24 asks the legislature to draw, and our courts as a result to draw between the various needs and competing interests. I've mentioned already this precautionary principle, and both NEMA, which I've referred to already, and the MPRDA prescribe a risk-averse, cautious approach, particularly in terms where there's a limitation on present knowledge about the consequences of an environmental decision. What that entails is that where there's a threat of serious or irreversible damage to a resource, the lack of full scientific certainty should not be used as a reason for taking measures that necessarily will result in, or that may result in, economic degradation. So it requires a cautious, risk-averse approach and a recognition that our scientific knowledge at any point in time may not be as complete as it can be, and that it may be down the line. Section 24.0, capital O, of NEMA lays down the criteria to be taken into account by the competent authority when deciding upon an application for environmental authorization. And it requires that the decision must be taken on the basis of all relevant factors, including any pollution, environmental impacts, or environmental degradation likely to be caused if the EIA application is granted or refused, measures that may be taken to protect the environment from harm, the ability of the applicant to implement mitigation measures and to comply with any conditions subject to which the application may be granted, where appropriate, any feasible, reasonable alternatives to the activity, any guidelines to departmental policies and environmental management instruments that have been adopted. And all of that information is required to be placed before the decision maker in a connection with the application for environmental approval. Our heads then take the court through the EIA regulations. They are there to regulate the procedure and criteria as contemplated in Chapter 5 of NEMA. That's relating to the preparation, evaluation, submission, processing, and consideration of a decision application for environmental authorization. And an assessment of impacts is required to be done and to form part of the EIA application process. In the circumstances of this case, and of TGS's application, that's the third respondent's application for environmental authorization of reconnaissance activities. The assessment that was required to take the form of a basic assessment report, or what I'll refer to as a BAR, as contemplated in Part 2 of Chapter 4 of the EIA regulations. And together with that, one is required to submit environmental impact assessment reports, inclusive of specialist reports, and all of that gets submitted to the competent authority. And if the court would like to have regard to exactly what is required, it's all contained in Appendix 1 to the EIA regulations. In terms of Item 2 on Appendix 1, the purpose of an environmental impact assessment is, amongst other things, in a basic assessment report, is, amongst other things, to determine the policy and legislative context within which the activity is located, document how the proposed activity complies with and responds to policy and legislative context, describe the need and desirability of the project, and all of this has to happen through an undertaking of an impact and risk assessment process. And that would consider cumulative impacts, determine the nature, significance, consequence, extent, duration, etc., and probability of the impacts occurring, look at possible alternatives and the degree to which any impacts can be reversed or mitigated. Other issues such as considering an irreplaceable loss of resources, for example, and how that could be managed or mitigated. All of those things would form part of that assessment process. So when we get to the relevant ground of review, I will submit that the BAR in this matter was lacking. What we know, which I've dealt with in the legislative context section of our heads, is that a BAR must contain, amongst other things, a description of the policy and legislative context in which the development is located, and an explanation of how the proposed development, conduct, activity complies with and responds to legislation and policy context, and a full description of the process undertaken to identify, assess, and rank the impacts of the activity. The BAR must contain an assessment of each identified potentially significant impact and risk, and that would include the nature, significance, consequences, the extent and duration, the probability of a risk occurring, the degree to which it's reversible, etc., which I've already canvassed. Then, my lady, the next piece of legislation that's relevant in this matter is the MPRDA. I'm not going to take the court through that in any detail, but it is contained in our heads of argument. The mining industry in South Africa is well regulated through the MPRDA and in terms of regulations issued under the Act. In terms of NEMA regulations, the Minister of the MPRDA, or Minerals Minister, is appointed as the competent authority to consider applications for environmental authorizations in respect of mining activities. And that's important because that comes up in the grounds of review. And the Minister of Mineral Resources may then decide whether or not to delegate that power in terms of NEMA. So a company that wants to undertake any kind of petroleum development in South Africa first has to apply for an exploration right to conduct studies, to determine the extent and location of petroleum deposits, for example, in the relevant area. And if one goes through the Act, one is taken through the process of an exploration operation and then ultimately seismic surveys, as in this case, exploration, and then ultimately production. The Act sets out a process that envisages how something that begins with an exploration right, survey, ultimately ends up in production. And that begins at Section 80 of the MPRDA and continues. But of importance, an exploration right may be granted for a period of up to 3 years, And the holder of that exploration right is then entitled to renew the exploration right 3 times for renewal periods of 2 years each. So a company could hold an exploration right over a particular area for a total of 9 years. If at some stage an exploration right holder makes a discovery of oil and gas, as may happen in this case if the decision stands and is implemented, then that company would have the exclusive right to apply for and be granted a production right, provided it satisfies certain conditions set out in Section 84(1) of the MPRDA. And those conditions do relate to unacceptable pollution, economic degradation, or damage to the environment. But the point I make is this: what happens in this case is simply the start of a much longer process. And ultimately, a production right may be granted for a period of up to 30 years. So the holder of a production right thereafter has the right to apply, the exclusive right to apply for and be granted successive renewals of the production rights, which themselves may be granted for 30 years at a time. And that is why this case is important. That is why it's important at this early stage of these proceedings that we ensure that the manner in which the decisions were taken was lawful, procedurally fair, that all relevant considerations were in fact taken into account, and that the minister and the DG before her had all relevant information before them in making the decision. Because the consequences of the decision, not just for my applicants, but for South Africa and for all communities impacted along the area of the activity, the implications are long-term and potentially very significant. If I may then turn in that context to the grounds of review specifically. Now, my lady will recall that the first ground of review is what I call the delegation ground. That ground arose from issues that became clear in the supplementary founding affidavit, the answering affidavit, and the replying affidavit. The ground raised 2 issues. The first is whether it was permissibly raised, and the second was whether it was good in law. Factually, I wish to just clarify the following. The applicant has been accused of raising this ground of review very late. The state respondents say that we raised it only in the replying affidavit. In fact, what happened is the following. The applicants raised the issue of delegation of power to the DG in its supplementary founding affidavit in relation to the involvement of PASA in the appeal process. Specifically, what the applicant said was the DG was presumably acting under delegated authority. And that's in the supplementary affidavit in paragraph 32 and repeated in 32, and it's repeated in 42. And you'll find that at record page 2452 and 2455. So the applicant says that the DG is presumably acting under delegated authority. The first and second respondents, in opposing this ground in their answering affidavit, sought to establish the basis of the delegation of power to the DG by relying on Section 103 of the MPRDA, Section 50A of NEMA, and the National Appeal Regulations. So the state respondents spent a significant amount of time explaining why the authority to the DG happened correctly under the MPRDA provisions. In their replying affidavits, the applicants then disputed this and said, actually, the first and second respondents have relied on the wrong provisions, and that the delegation could only be made under Section 42B of NEMA. Now, there is a long argument around whether which one of those arguments is legally correct. I will make it clear, as I've said, we don't persist with this point. I raise this because it becomes an issue down the line in relation to costs. But importantly, there is a valid and substantive legal argument about the correct provision that the DG ought to have been delegated under. More importantly, despite this whole kerfuffle in the answering affidavits about what provision the DG was authorized under, at no point did the DG himself say on oath anywhere that he has a written delegation, and a written delegation is what's required by the statute. And his failure to do so is notable. Instead, what you have is the Minister of Environmental Affairs telling the court on oath that the Minister of Mineral and Petroleum Resources delegated this power as a competent authority to the DG. The Minister of the Environment does not explain how she knows this. She doesn't put up an affidavit confirming this by the Minerals Minister. And she doesn't do the simplest thing, which is to attach the written delegation of the DG. None of this was done. So what we're left with on the papers is hearsay evidence by Minister Creasy. Now, we accept fully that what the applicant did not do in this case was to amend its notice of motion to review and set aside a purported delegation that the respondents rely on. The respondents say to this court on oath, there is a delegation. That delegation applies, that delegation delegates the power to the DG, and what we ought to have done was to review and set aside, seek to review and set aside that delegation. We have not done so. So we don't persist with the delegation ground, but we make it clear to the court that the legal basis for questioning whether the delegation was lawfully made under the provisions that the respondents say it was are grounds for, are with merit, have merit. Now, importantly, the applicant could not have known any of this before the answering affidavits, before they saw the basis of the respondent's case in the answering affidavits. And we persist, we stand by our submissions that there was no lawful delegation to the DG, but we accept that in process what we ought to have done was to seek to set that aside. So we don't persist in that ground further. If I can then move on to ground two. Ground two is a failure to consider EIA documents. The DG purported to grant the environmental authorization, we say, without considering a BAR assessment, basic assessment report, without considering specialist reports, environmental management program, or comments from interested and affected parties. And that, we say, is all of that is in breach of Section 24 of NEMA, read with Regulation 18 of the EIA regulations. Now, the case before the court in relation to this ground is as follows. The respondents the applicants say, what is clear from the record decision is that it is missing a whole series of these documents that ought to have been taken into account by the DG in coming to his decision. The respondents attempt to rely on statements in the affidavits of the DG and the minister, saying that the DG had the relevant reports before him when he took the decision, and they rely on the decision itself, which refers to the contents of refers to the existence of reports. But critically, none of this is borne out by the Rule 53 record itself. So the record of documents before the DG when he made the decision, and you'll find that at JWS 5, my lady, which indicates that the only document that served before the DG was in fact the application form that was submitted by the third respondent to PASA, which is the process, together with appendices to that. And if we go to record page 2484 of the papers, what one sees there is an index that ultimately was prepared by my attorneys to the record of decision. And if one looks at that index, what's clear is that one, all it contains is the application by the third respondent. Two, it has a screening report, but the rest of what was before the decision maker was a locality map, proof of public participation, consent letters, and the like. Notably, what is missing is the BAR, specialist reports, the EMPR, comments from interested and affected parties. All of those things one would traditionally expect to see in a Rule 53 record of an environmental authorization such as this one. And they are all required by the EIA regulations. Now, the only response that the respondents offer in response to this glaring deficit in the Rule 53 record is, well, it doesn't matter because the DG tells us in his affidavit, well, first of all, that he tells us in his decision that all the information presented to the department was considered and that he authorized TGS to undertake the seismic surveys as described in the BAR. So he says that in his decision. And the respondents say that that is sufficient. That shows that if he referred to it in his decision, he must have had it. But notably, the DG filed an affidavit before this court. And he never says on oath that he considered the BAR or other specialist reports in coming to his decision. His affidavit details at length the legislative context, the role of PASA, etc., but it notably does not deal with this critical issue. It doesn't say what he took into account. All he says is he confirms the correctness of the minister's affidavit. And our courts have held that a deponent needs to do more in a matter such as this than simply confirm the correctness. He needed to have told this court, in circumstances where it was his decision that was challenged, what he had before him. He did not do so, and he did not do so in circumstances where the glaring deficiency of what was before him was properly raised on the papers. Also notably, he did not do so in circumstances where the record itself was the subject of much correspondence that's contained in the papers, and I can give your lady the reference to that if you would like. I don't have it to hand at the moment. But there's much correspondence in the papers, specifically between my attorneys and the respondents, first and second respondents' attorneys, around whose record was being submitted. Was it the DG's? Was it the minister's? And as to the correctness of the record. The respondents therefore had ample opportunity to supplement the record. And they chose not to do so. That's notable. Now, the effect of the argument is that the respondents asked this court to disregard the fact that a Rule 53 record evidences a lack of required documentation. And in the face of that, the respondents tell this court that it must accept a bold statement, and not even just a bold statement, a statement that infers something by the minister. The minister infers that the DG had everything before him when he took the decision. And the DG, as I said, says nothing. That would ask, if the court were to accept the respondent's argument in that regard, it would be asking this court to completely undermine the purpose of a Rule 53 record. It would enable a situation in our courts where a deponent is entitled, a decision maker is entitled to come to court and say, ignore what I've provided in a Rule 53 record. It doesn't matter what the record has. I'll tell you what was before me. And if this court were to do that, it would disregard established precedent and constitutional court precedent at that on the importance and the weight of a Rule 53 record. in the Constitutional Court, it's quite an extraordinary argument to make, and would be quite an extraordinary finding for this court to hold. And this is clear. The importance of the Rule 53 record is clear from the Constitutional Court in the Helen Suzman Foundation case, which is 2018, Volume 4 SA 1 CC. And the relevant paragraph is at paragraph 16. In fact, I think it starts at paragraph 14, where the court says, our courts have recognized that Rule 53 plays a vital role in enabling a court to perform its constitutionally entrenched review function. The Constitutional Court then quoted the Democratic Alliance case in the SCA, in which the SCA said, quote, without the record, a court cannot perform its constitutionally entrenched review function, with the result that a litigant's right in terms of Section 34 of the Constitution to have a justiciable dispute decided in a fair public hearing before a court, with all the issues being ventilated, would be infringed. And the Constitutional Court went on to say, at paragraph 15, the filing of the full record furthers an applicant's right of access to court by ensuring both that the court has the relevant information before it and that there is equality of arms between the person challenging the decision and the decision maker. Equality of arms requires that parties to the review proceedings must each have a reasonable opportunity of presenting their case under conditions that do not place them at a substantial disadvantage vis-à-vis their opponents. And in the last paragraph I want to quote from the Constitutional Court, the court said, in Turnbull-Jackson, this court held, quote, undeniably, a Rule 53 record is an invaluable tool in the review process. It may help shed light on what happened and why, give the lie to unfounded ex post facto, after the fact justification of the decision under review, in the substantiation of, as yet not fully substantiated grounds of review, in giving support to the decision maker's stance, and in the performance of the reviewing court's function. So a Rule 53 record is more than merely a tick box exercise that has to be complied in a review. It serves a vital and very, very important function. Our Constitutional Court has highlighted this, and we submit that one cannot clearly explain away these huge gaps in the record that is before this court by a virtue of an affidavit by a minister saying the DG had everything before him because he referred to it in his decision. That is not sufficient. It is particularly not sufficient where the DG himself made an affidavit before this court and chose not to take the court into his confidence and tell the court what was before him. And it's particularly so when there was ample opportunity for him to do so. We also point out in our heads of argument that the DG also didn't have the parser file before him, which the minister says that she had in front of her. And we accept that the minister says that she has a wide appeal, but we just point it out for the sake of completeness. The DG, there's a reference in the minister's decision to parser reference 12/1/40. And that's in paragraph 3.1.4 of the appeal decision. So the minister also refers to something else, which was not before the DG. We know on the papers before the court that it is parser that assists the department with compiling all of the applications, receives the applications for environmental authorization, and takes it through all the way we submit until placing the draft decision before a decision maker to consider and sign. So the fact that the DG also didn't have the parser file is relevant. So on balance, we submit that on the evidence before the court, the DG granted the environmental authorization without considering critical relevant information. The BAR, specialist reports, the EMPR, comments from interested and affected parties, and all of this we submit was in breach of Section 24.0 of NEMA, read with Regulation 18 of the EIA regulations. And for all those reasons, we submit the DG's decision stands to be reviewed and set aside on that ground alone. Now, in response to this argument. The respondents say, well, even if you're right in all of that, the minister had a wide appeal. The minister had a broad power, it was a wide appeal, and a wide appeal, they submit, cures the irregularity. So they say even if the DG did not have the relevant documents before him when he took the decision, the irregularity would have been cured by the wide appeal before the minister. But we submit that that's not correct. It is not correct in our law that a wide appeal cures everything, always. Our courts have held that whether the holding of a proper appeal cures an irregularity or defect in the initial process depends on the circumstances of each case and on the materiality of the procedural defect. And the reference given in our heads is to the case of Slagment versus BCAWU. That's an appellate division case, 1995, 1SA 742, appellate division. We also refer in our heads to the to Hoekster's textbook on this matter as a leading authority on administrative law. And she points out, we quote, the link between process and outcome also bears on the question whether it is possible to cure an initial failure to observe fairness by means of an appeal, and suggests that the answer is generally no. So in Slagment, which I referred the court to, the appellate division noted that it was not possible to lay down a general rule as to whether a failure of natural justice may be cured on appeal. Some defects in the initial hearing are so fundamental, the court said, as to be regarded as incurable. Now, that was also followed in the case of Monig versus Council of Review, 1989, 4SA 866, a case of this division, at 883, capital E. Now, the respondents tried to distance the court from reliance on Slagment because they say the facts in Slagment were very different to this. And they're correct, the facts were. That was in the context of labor law. This is not. But we're not relying on the case for the similarity of factual basis. We're relying on the case for the legal principle enunciated therein. That legal principle is a broad legal principle about when a wide appeal cures a flaw in the initial decision. The law on that is not dependent on whether Slagment concerned issues of labor law rather than environmental. So we submit that the Slagment is relevant and appropriate for this court to consider. In this matter, the lack of fairness in the decision making is significant, and we submit it's incurable on appeal. The DG, critically, did not have before him, I've been through this with the court, but he did not have the key documents before him on which he claimed his decision was based. He didn't even consider those specialist reports and interested and affected parties' comments. So, at best for him, he relied on Passer's recommendations. At best. He doesn't even say that. That is me being generous to the DG. So fairness requires that a decision maker must not only have all the relevant information before him, but in the process of a review before our courts, he must be able to tell the court what was before him and show the court that it was before him by providing an appropriate record. The DG did not. And we submit that the idea that an error of this magnitude could be cured on appeal renders the entire environmental authorization process irrelevant. And I took this court earlier in my submissions through the entire legislative framework, which is complex and which is designed to set out the process by which someone applies for environmental authorization, all of the documents that are required to be submitted. All of those things are submitted for a purpose. It's so the decision maker can do what he or she is meant to do under the Constitution, under NEMA, to balance those competing factors How does he do that? He does it by having all relevant information before him. We submit that what the record shows here is that he did not do that, and that cannot be cured on appeal by the minister. The environmental authorization process is a critical component of the rights and obligations set out in NEMA. And we submit that this irregularity cannot be cured and would set a far-reaching precedent for this court to adopt the respondents' arguments in this regard and undermine the entire structure of NEMA. For all those reasons, we say the decision of the DG stands to be reviewed and set aside. If I can then move on to ground 3. Now, ground 3, my lady, is the unlawful reliance on PASA when taking a decision. Let me start by saying this. We are not suggesting that PASA took the decision itself. Somewhere in the volumes of papers filed on behalf of the respondents, I recall reading that. We're not suggesting that PASA took the decision. But what we are suggesting is that PASA took on the role of the department in circumstances where it was not authorized to do so. So we say PASA adopted an impermissible role in the environmental authorization and appeal process. It purported to comment on the appeal as a competent authority, despite being not lawfully entitled to do so. We accept that PASA is an organ of state, exercising a public power, performing a public function by virtue of the designation by the minister in terms of Section 70 of the NPRDA. And we accept that it is required to perform the function set out in that act and any other function that the minister determines from time to time. And one of those functions, and it's important that we know what PASA's core function is, and that is to promote offshore oil and gas exploration. It is also the national custodian of petroleum data under the DMR. Now, we accept that PASA, in its capacity of organ of state, or even as an interested and affected party, had the right to comment on an appeal. That's fine. It could comment on an appeal, and that was confirmed in the Green Connection case in this division, where this court interpreted the appeal regulations to mean that PASA qualifies as an interested and affected party and therefore could submit comments.
May I just inquire, is that one of the grounds of appeal in the pending SCA appeal?
I believe
or one in respect to which leave is now being sought?
Can I just take instructions?
Thank
I believe
you.
it is, but I would just like to be correct now. Well, in fact, we're not sure.
Okay.
My junior's going to have a look if she can find it, but I'm not sure. I don't want to make a submission that I'm not sure about.
Because you'll understand my difficulty.
I understand your difficulty. And the answer to that is this, which is, it does not matter. Our case is not to question. We accept that PASA could make comments as an interested party. We accept that it could make comments as an organ of state. But while it was permitted to comment in the capacity, it didn't do that in this case. Here, it's purported to comment in the capacity of a competent authority. And it's common cause that it was not the competent authority. It is, in fact, its role is so broad that if one looks at the environmental authorization itself, for inquiries on the environmental authorization, you're required to contact an official of PASA. That's on the first page of the environmental authorization. So what we have here is we have PASA adopting a position that we submit goes too far. And I'd like to take the court through a few instances of that. If you'll just bear with me. So the response reports, that is JWS 8 to JWS 12, each contain a section for comments by the department. The heading is department. And those sections we submit were completed by PASA. So if one looks at page bear with me, my lady, 2940, under comments, there's a table. This is the completed appeal response report. So this is a report that starts off its life as a document that the applicant fills out, and the applicant fills out its ground, or the appellant fills out its grounds of appeal, and then the document. So in the papers, you have one version of this report that only has the left-hand side column filled out, and then you have the completed ARR, which has the second and third columns filled out, and that is a responding statement by the applicant and then comments by the department. And all of this then finds its way to the minister, who considers it and makes a decision. When you look at page 2940, what you see under comments by the department is the following, in the last column. It is the agency's view that the precautionary approach principle was considered and followed throughout the understanding of the EIA process, and proceeds to set out what the agency's views are in relation to the state of scientific knowledge. We submit what's clear from that is that section was filled out by PASA, the Petroleum Agency. And if one goes to page 2453 of the record, we take the court through why we say that is so. It's part of our supplementary founding affidavit. And then if you go to page 2969, if we're still unsure about PASA's role in preparing this document as the competent authority, if you go to page 2969 of the papers, that's the last page of the appeal response report. And there what you see is two signatures. There is a position where the ARR comments by case officer are signed, and that is Sinazo Mnyaka. And as we show, if you look at page 1 of the environmental authorization, Sinazo Mnyaka's email address is there, it's at PASA, and in our papers we conducted a LinkedIn search to show that, to the extent that this court would take notice of that Sinazo Mnyaka works for PASA, but it's clear even just from the environmental authorization, and that hasn't been denied. And then approved by the supervisor is the second signature on the page, P. Ngesi, also an official of PASA. So this ARR was prepared and signed off by PASA officials. So the role of PASA here has extended far beyond simply assisting, what the respondents in their affidavits refer to as assisting the department in the technical requirements of an environmental authorization. Moreover, Minister Creasy herself refers repeatedly to, quote, the competent authority's response as the ARR document. And you will see that at Appeal Decision Annexure A3, paragraph 2.4, record page 218. And we deal with that in our heads, paragraph 95. My lady, the existence of a pending appeal does not render the High Court judgment in this case, trying to remember the name, suspended, I think was the word that was used in the papers. It's not suspended. It is a judgment that is on appeal. It remains in force. We have no way of knowing what the court there will determine on appeal. It is open to the applicants to raise this ground, as it does on the facts of this case, which are different to the facts of Green Connection. And so we submit it is a valid ground of review. But if my lady would permit me, I'll try and determine before I stand up in my reply what the particular grounds are that are appealed, because some of them are appealed and some are not. And hopefully I can assist you all. Perhaps my learned friends are in a better position to do so.
It's really in the context of apparently, from what I understand, leave has been granted to the SCA in respect of certain grounds, from what I could pick up in the papers, or the heads rather.
Yes.
But an application has been made by way of petition, I would assume, for leave on other grounds. And I'm just not quite sure which grounds fit in where, and it's probably unfair to ask you because the respondents would probably be in a better position to tell me. But my understanding certainly is that if something is pending, its effect is suspended in most instances, and I'm just reluctant to regard it as authority in this division in those circumstances. I don't want to put any higher than that.
Yes.
Okay.
We wouldn't suggest that, we're not asking this court to rely on it as authority.
Okay.
The complaint, as I understand it from the respondents, is that we're not entitled to raise this in the face of the appeal. That can't be right as a matter of law. We're entitled to raise this ground. Once the SCA or High Court ultimately decides a matter, then it's different. Then
I understand what you're saying, because it's not this order it's not the Green Connection order that's being asked to be implemented. I understand that argument.
Yes.
But it would be helpful if I had some idea.
Yes.
Okay.
We'll do our
Thank
best
you.
to do that, or I'm sure my learned friends will
Excellent.
assist.
Thank you.
If you just bear with me for a minute, my ladies. I'll double check
It's fine.
and deal with it in reply. All right. Then, if we can move on to the fourth ground. Now, under this heading, my lady, we deal with a whole. This is the one that perhaps caused some confusion in the head. Under this heading, what we've tried to do is to put together all of the different sets of material information which we say was not considered by the decision makers, or which was not appropriately considered. And we call that the fourth ground, a failure to consider relevant considerations. The first one is a failure to consider the factors in section 63 of the Integrated Coastal Management Act, ICMA.
You just bear with me a moment.
Yes, ma'am.
So, underground, your new ground 2, if I can put it that way, at page 30 of your heads.
Yes, just bear with me.
Failure to consider EIA documents. Then we have the new, I'm calling it new, but that's not intended in any way to something other than how it appears in the heads.
Yes.
Failure to consider relevant information. And you'll appreciate that you've all had a lot more time than I have to have read through all these papers. So I'm just trying to understand if there are two completely distinct grounds, or whether some of the EIA documents which the applicants contend were not considered falls under failure to consider relevant information.
Yes, perhaps we should have labeled them slightly differently to be clear. So the ground 2, which is the failure to consider EIA documents, is the ground around what was missing before the decision maker.
In terms of the regulations,
EMPR, the VAR,
okay,
the specialist reports. This ground 4 deals with the failure to take into account ICMA, a failure to consider some of the things that ought to have been before him. So there's some measure of overlap.
So there is a measure of overlap. I think that's where my confusion arose.
No, there certainly is a measure of overlap. It includes, for example, the defective EMPR, but the emphasis is slightly different. And that's why it finds its way into the fourth ground.
Thank you.
My lady, if it would assist, I'm not sure that it assists at this point. If it would assist, I'm happy to provide my lady with a reference to comparing the heads to our founding affidavit and supplementary affidavit.
Look, I think that the table I got on Friday afternoon has helped tremendously.
Okay.
But it's just this one, and you'll appreciate that I'm not an expert in environmental authorizations, so I just needed to understand exactly what I was dealing with.
Indeed, my lady.
Okay.
No, this is...
Let's see how the arguments go, and then if necessary we can revisit.
Okay, good. Right. So, ICMA is a critical piece of legislation in the context of this decision. It is one of the specific environmental management acts listed in NEMA. It applies to South Africa's coastal waters, which include South Africa's territorial waters and exclusive economic zone. This project that is at issue in these proceedings takes place in South Africa's exclusive economic zone, and so it falls within the coastal zone and is a coastal activity regulated by ICMA. That's not in dispute. Now, the objects of ICMA are set out in Section 2 of the Act. They are essentially to provide a framework for the coordinated and integrated management of South Africa's coastal zone, and to preserve, protect, and enhance coastal public property and give effect to South Africa's international obligations for coastal property. Our heads set out in detail the provisions of ICMA that are relevant to this application, and you'll find them at page 19 of our heads, paragraph 41. I don't wish to repeat those, but critically, ICMA provides that coastal public property is vested in the citizens of the Republic, and it's held in trust and managed on their behalf by the state. The state is therefore under duty to ensure that coastal property, public property, is managed, conserved, enhanced in the interests of the community as a whole, and that is the language of the statute, in the interests of the community as a whole. And this means protecting collective interests and future generations. You'll find that in Section 12 of the Act. The Act also says in Section 21 that an organ of state responsible for controlling or managing any activity in coastal waters must do so, A, in the interests of the whole community, and B, in accordance with international law. Now, it's notable that Section 63 of ICMA applies when an environmental authorization in terms of Chapter 5 of NEMA is required for coastal activities, and the provision requires the competent authority to take into account all relevant factors, including a series which I will get to. And Eddie, can I just ask, I'm in the middle of this ground, but I see that we're getting towards tea time. Should I stop here and continue after tea?
I think that's probably a good idea. 10 past now, 25 past. Would that work? Thank you. We'll take the 15 minutes adjournment.
authorization in terms of Chapter 5 of NEMA is required for coastal activities. The provision requires the competent authority to take into account all relevant factors, including the following: whether coastal public property will be affected by the activity, and if so, the extent to which the proposed activity is consistent with the purpose of establishing and protecting those areas. And you will find that in section 63(1)(c) of ICMA. Then, if the activity affects coastal property, whether it is inconsistent with the objective of conserving and enhancing coastal public property for the benefit of current and future generations, that's 63(1)(h)(1), and then whether the activity would be contrary to, quote, the interests of the whole community, that's section 63(1)(h)(7). So, by requiring that consideration be given to the interests of the whole community and conferring a special legal status on coastal public property, which affords these areas a particularly high level of protection, ICMA introduces concepts which are not present in NEMA, and that's important. They're not present in NEMA, they're not present in other environmental laws. So the assessment of those factors can only happen if a decision maker considers ICMA specifically. So despite the importance of ICMA, and especially section 63, despite the importance of that to the environmental application in this case, the basic assessment report only made a single reference to section 63, and it contained no details of its provisions and no analysis of their implications. So the environmental authorization itself made no reference to ICMA at all. The appeal decision simply stated in general terms that the provisions of ICMA and section 63 were considered. So what we left with then is a DG's decision that says nothing at all about ICMA, and an appeal decision that just states that it was taken into account. The appeal decision does not identify any portions of the DG's decision which considered ICMA factors. Couldn't do so, of course, because we submit the DG's failed to take ICMA into account. And secondly, although the Minister purports to have considered ICMA factors, she fails to set out any findings in respect of the ICMA factors. So what one would have expected was for the Minister, in relation to a statute as important as this in the context of an environmental authorization that specifically triggers ICMA, we would have expected both the DG and the Minister to do an assessment of the factors in ICMA and show why each one of those factors were considered and regarded as good or bad, accepted or not accepted, but somehow to show this court that in fact, or in anyone reading those decisions in fact, that ICMA was considered. The BAR itself doesn't sufficiently engage with the requirements of ICMA. So all of this leads to a conclusion that the decision was made without relevant information before the decision makers. Had they done so, had both the Minister and the DG considered section 63 specifically, at a minimum what we would have wanted to see was whether the proposed project, an indication in writing in those decisions, of whether the proposed project would affect coastal public property, for example, whether the proposed project is consistent with the objective of conserving, protecting, enhancing coastal public property for the benefit of current and future generations. That's the language of the statute. Whether the activity would substantially prejudice any coastal management objective, whether it's socially and economically justifiable and ecologically sustainable and consistent with Section 24 of the Constitution regarding the interests of future generations in inheriting that coastal public property. So, there are a host of factors. What are the effect on living organisms that are dependent on our coastal environment, for example? But none of those there was no attempt made by either the DG or the Minister to consider the factors in Section 63 of ICMA, to evaluate and assess them, and to express a conclusion having done so. All we have is the Minister saying, I've considered it, it doesn't apply. So we have a BAR that fails to do what it's required to do under ICMA, and we have a decision that follows that itself doesn't have relevant, is not based on relevant considerations being taken into account. Again, one of the arguments in response is that anything lacking, any deficiency in the DG's decision was cured on appeal. We submit they could not have been cured on appeal because the Minister did not actually address, she didn't go into the process of addressing the ICMA grounds herself. She didn't evaluate the Section 63 requirements. All she does is mention that they would be raised, and she considered the BAR and was satisfied that the provisions of ICMA and 63 were considered. That we submit is not sufficient, particularly in relation to a statute as important as this, and which deals with issues that are not dealt with in NEMA. So the Minister can't say, well, I considered this through consideration of broader factors in NEMA. She can't, because NEMA doesn't deal with what ICMA deals with. Now, this issue was raised in the Green Connection case, but as far as we're able to determine, it is one of the issues that is on appeal, the ICMA factors. We submit in our heads of argument that, in fact, if you look at Green Connection, that the DG in this case does far less than what was done in Green Connection, and in Green Connection that ground of review is upheld. But I take the indication from the court that there is concern that this is on appeal, and I deal with that here, save to say one thing, which is that the respondents argue that the Green Connection is distinguishable because in this case we have the Minister and DG affirming under oath that they considered ICMA, and therefore that Plascon-Evans applies. But with respect, and Plascon-Evans you'll see is thrown liberally throughout these papers, but in most instances it misses the point, and in this one it certainly misses the point. This is not a Plascon-Evans situation. We're not asking this court to make a factual finding that the deponent lied. The complaint here is one of legal adequacy. This is a procedural complaint. It's a complaint that says that the decision makers were required to take into account ICMA. And legally, what is required? We submit that what is required to show that you took something into account is actually evidence that you've taken into account, not the mere say-so. And certainly not the Minister saying that the DG took it into account without any further explanation for what she bases that on. So we submit that the reasons here given by the Minister do not disclose that this mandatory condition was complied with. And in the face of that, we submit that this ground of review must be upheld. The next ground of review is that of the unbalanced need and desirability assessments. Item 2C of Appendix 1 of the EIA regulations requires the BAR to describe the need and desirability of a proposed project and its alternatives. And in assessing the need and desirability of the seismic survey, the BAR considered only the benefits, we submit, only the benefits of production of natural gas, that the BAR summarizes the positive aspects of the projects and not the negative. That's the shortened version of this grant review. The positive aspects were the opportunity to identify potential oil and gas resources within the project area. But what it doesn't do, and production by the respondent. and that they would need to be assessed in detail during subsequent scoping and EIA processes, should drilling and exploration or production. Now, we accept that the way in which this works is that detailed studies will be reviewed. The sheer it's necessary to put forward and that need and desire positive and negative impacts. High Court upheld the asymmetric as clear of green connection. I don't think it's. We simply say that. No, set aside. The next ground of review.
Following your heads of argument, which is
Thank
always a great relief to a judge.
Yes, no doubt.
Not slavish adherence, but just that one has an idea where you are. Thank you.
I'm glad that they're of assistance, my lady. That was the intention. Now, if we move on to the defective EMPR, this ground of review is premised on the fact that the decision paid little regard to the social impacts on the community when it comes to providing redress in a meaningful manner. So, in short, the EMPR fails to comply with Appendix 4 of the 2014 EIA regulations because it does not properly identify impacts and risks or set out adequate mitigation, monitoring, and management measures. If one goes to RA 14, if you just bear with me for a minute, my lady, I'll find you the correct page number. RA 14, and I think our heads incorrectly refer to RA 11, but the relevant portion
I've got
that
the updated head, so with the correct reference of RA 14.
Good, thank you, my lady. If one looks at RA 14, there is a table.
Did you give me the page
Yes,
number?
sorry, it's 4700.
Okay. It is in your heads, but there were two references.
Yes, 4700 is the relevant one. A lady will see that there's a table at page 4700, and it sets out, it's a comparison of the EMPR with social impact assessment, SIA. What we see there is on the left-hand side column, it's very small, but if I hold it far enough away from my eyes, I think I can manage. A representative from TGS should consult with traditional leadership of the affected communities to establish what their understanding of meaningful consultation is, and how communities should be consulted in future. And it goes on. The argument in this regard is that what's missing in the mitigation, highly missing from the EMPR, and that includes things like participatory processes and workshops where communities are engaged in experiential learning, which the document says is important to avoid the need for social unrest. I assume what that means is that all of the risks and recommendations in the social impact edition for the seismic survey means is that it permits the third respondent to avoid engaging directly with fishing communities when implementing the mitigation measures.
May I just ask how, if at all, that bears any relation to abandoned ground 2, original abandoned ground 2, public participation?
It's different. It is a different ground.
Okay.
This is an ongoing engagement with the community as opposed to public participation prior to the environmental authorization being taken on the decision. It is a form of public participation, I accept that, the EMPR. And in doing that, it means that the applicant, TGS, can go ahead with its authorized activities really without implementing these mitigation measures. And it's the social impact assessment is really an assessment of how the applicant has to engage with communities. And it's relevant because we saw in ICMA the importance of the community as a whole, the importance of the notion of public coastal property. And so when you allow an applicant, successful applicant for environmental authorization to bypass engagements with the community in this way, even where a social impact assessment required it, it effectively means that one of the fundamental principles in which environmental management must happen is being undermined.
Could I ask
yes.
you then, given that it's not the ground to public participation point, what would be required as ongoing engagement while would that be while this seismic exploration activity is underway, or how would that work?
Yes, so can I clarify first that the review ground here is not a failure to comply with public participation. It did not have impacts that came from a social impact assessment that should have found its way into the EMPR and ultimately before the decision maker.
So
that's the ground of review.
All right, so nothing about
that you see on page 4700 found its way into the EMPR. And we say, therefore, that the EMPR was therefore materially deficient and that it fails to comply with items 1.1f, G, and K of Appendix 4 of the EIA regulations, and it's a breach of regulations 19.4 of the EIA regulations, read with section 24 N2 of NEMA. Is reviewable. If I can then move on to the next ground, which is insufficient information on marine impacts. Now, this ground of review is the subject of many, many, many pages in this record. In fact, the ground of review relates to the gaps in knowledge and the gaps in information that we say resulted in fatally flawed assessments. And those assessments are the acoustic study, and we say that there were flawed assumptions on which the studies were based. So the ground asserts that because of those gaps in knowledge, the precautionary principle, which I referred to at the beginning of my submissions, was not followed.
Sorry to interrupt you.
Not at all.
From what I understand, in the heads of argument, the applicant's approach is one doesn't need to look at what the experts have to say in the sense of making credibility findings, but one has to look at what the applicant's experts say in order to highlight or emphasize the gaps of knowledge. Now, my question is, certainly I think it was Dr. Forney, if I'm pronouncing her name correctly, her report was produced about 18 months after the authorization. I'm not going to pretend that I can tell you when all the other ones were produced. As you rightly point out, there's a fair bit of paper. But if you could just assist me there, because obviously one's got to draw this very clear distinction between review and appeal grounds. Which reports of the applicants served before the DG?
If I can answer it in this way, my lady, you're correct that the expert reports in this matter were prepared the applicant's expert reports were prepared for purposes of this litigation. They were not prepared as part of a submission, although some of the issues raised in Dr. Forney's reports were raised by the applicant in their comments. So they ought to have been considered by the decision makers anyway, and I'll go to that. But the point of this ground is that we're not asking this court to evaluate one expert against another. That's not what we ask. We put up the evidence of Dr. Forney and Dr. Harris and the other experts to show the kind of information that ought to have been before the decision maker. It's not for us to have done that work, quite frankly. These are things that ought to have been considered by the decision maker. So, for example, under this ground, the decision makers relied, and their expert, whose double barrel name I keep forgetting, if you'll bear with me, I think it's Valerta Hernandez. Their expert refers to a report, for example, from 2019. Dr. Fournay, in her evidence, shows that there is a gap because, in fact, there is a later report that ought to have been considered.
But what do I do with this? Because I'm just raising this with you because I'm not quite sure how it helps. Ex post facto, expert evidence used for the purpose of showing that there are gaps when it was never before the decision maker in the first place. Is that not indirectly asking this court to make some kind of or expressive view, which is really very much in the domain of the experts and not this court, as to whether or not anything they put forward should have been taken into account by the administrator in the first place? That's my concern. I don't know if I'm expressing myself
I
clearly.
understand the concern. It's a valid concern. My response is as follows, is that even the information before the decision maker identified that there were gaps in the scientific information. That was one of the issues that the Western Cape Department of Environment raised, the lack of scientific knowledge.
But is that not a different
once
argument?
there is, yes, and so if I can just develop this point, then what they were required to have done was to adopt the precautionary principle. That precautionary principle is contained in NEMA and it's reinforced in fuel retailers and upheld in fuel retailers at paragraph 98. It essentially says that sustainable development requires a consideration of all relevant factors, and that the limits of current knowledge about the consequence of decisions in this context require a risk-averse and cautious approach. And it compels every decision maker, when faced with the impacts in respect of where there's some level of uncertainty or a lack of information, or where the risk to the environment is substantial, to err on the side of caution and protection of the environment. That was held in fuel retailers at paragraph 98. So our submission in relation to this ground is this: the gaps in knowledge that the respondents accept exist. They may differ about the extent of that gap in knowledge, and they may differ about the specifics of it, but they do accept that there's a gap in knowledge. Their own expert accepts that as well and says he's done what's reasonable for him to do. We submit that's not sufficient, that this situation is catered for by the precautionary principle. And the precautionary principle requires that you err on the side of caution and not grant a decision that may have severe environmental consequences where you don't have the scientific basis to make that decision knowledge. It's not for this court to accept the correctness of her evidence or not, but just to reinforce that even on the respondent's own version there were these gaps, and to give some content to those gaps. And I accept fully that I'm not asking this court to make a ruling on which expert is correct. Now, the BAR purported to apply the precautionary principle by using a mitigation hierarchy, but we submit that the proper application of the principle would have taken into account the significant gaps in knowledge resulted in a refusal of the environmental authorization on the basis of that precautionary principles. And it is important to note that in Dr. Fournay's report, she actually does credit the department's reports and finds things in it that she found to be correct. It's a balanced report, but again, I don't ask the court to go into that. It's also notable that the DG's reasons for his decision made no specific reference to marine impacts, didn't engage with these issues at all. So for all of those reasons, we submit that the DG and the Minister failed to give adequate consideration and to apply the precautionary principle correctly, and that amounts to a reviewable irregularity. Then to move on to insufficient information on cumulative impacts, as required by items 2D and 31J1 of Appendix 1 to the EIA regulations, including cumulative impacts associated with both similar and diverse activities. So those include impacts of, for example, other exploration projects in the project area, and cumulative climate impacts from exploration of oil and gas. In short, well, the respondents' response to the survey will emit so little, but except even if that's correct, it doesn't address the sound and pollution impacts, which is what the core of our case is about. Currently, then, the cumulative impacts with which this environmental authorization was assessed was on the basis of that one application. But what we say had to have happened was that the decision makers had to have been made aware by their independent experts, one of whom is an expert in the case, that there are in fact cumulative impact on the decision. Seismic surveys and ultimately perhaps exploration and production to take place in project area A, let's call it, and ignores the fact that project area gas production, for example, that the impact of one will impact on the other effectively. And we are talking about the sea. We're not talking about something that can be carefully cordoned off. It's not disputed that that the sea is a moving, I think in our papers we call it a kind of a moving body of water. So it's not easy to, as one might in a construction context, fence off an area, cover it up, close up a hole. This is a moving, dynamic ocean. So all we say in relation to this grounds is that Mr. Whitlow himself, who is the EAP or the EAP, he's a technical director at EIMS, and he's an expert. So he conducted the study for the department, and he provides an expert affidavit in these papers. He knew, and he says on his papers, that he was aware that there are exploration activities in adjacent blocks, 3B, 4A, that's block 2. And in his affidavit, he states that his company, EIMS, has extensive and recent experience conducting public participation processes for similar seismic survey activities, including in the Orange Basin, which is where this is. So we have a situation in which EIMS was appointed to assist with environmental authorization for seismic surveys, not just on behalf of TGS, but also others. And we submit that is a critical factor that the Minister ought to have taken into account in deciding whether to grant this authorization. The EIA regulations require the BAR to contain an assessment of each identified potentially significant impact and risk, including cumulative impacts. And cumulative impacts are defined in relation to an activity as, quote, past, current, and reasonably foreseeable future impact of an activity, considered together with the impact of activities associated with that activity. That in itself may not be significant, but may become significant when added to the existing and reasonably foreseeable impacts eventuating from similar or diverse activities. And you'll find that at Regulation 1 of the EIA regulations. The first and second respondents do not deny the applicant's allegations that they were aware at the time that they took their decisions of the existing rights that are held for license blocks 1, 2, and 3. Their defense instead relies on the fact that the minister, the environment minister, had regard to the assessment of cumulative impacts in the BAR and was satisfied that they had been assessed. And they state that the BAR assessed all reasonably foreseeable cumulative impacts and assessed a worst-case scenario of 3 concurrent seismic activities and the application of a mitigation hierarchy. And you'll find that in the second respondent's answering affidavits from paragraph 61.5 to 61.7. But the marine assessment stated that other exploration activities are foreseeable, but that reasonable assertions could not be made about them on account of a lack of information available, primarily geological. So what we have is a situation where the minister says, oh no, I took all reasonable steps, I'm happy that we've considered all reasonably foreseeable occurrences. But we also know that their own expert is aware of other applications in the general vicinity that may well have had a cumulative impact on this application. It does not say that he told that to the minister when he ought to have. And we submit that the minister could not, in the face of the marine assessment, which itself says that reasonable assertions could not be made about foreseeable activities because there's a lack of information. When you put all of that together, then we submit that actually there's a reasonable possibility that these exploration activities could take place simultaneously with TGS's seismic activities, and then would have a cumulative impact which was not assessed. So we submit it was reasonably foreseeable in those circumstances that the decision makers, when taking their respective decisions, that the exploration activities in blocks 1, 2, and 3 could overlap with TGS's seismic survey. And it should have been considered. It was not considered. It was relevant information that ought to have been before the decision maker and was not. And it's not just information that's tangential, it is critical relevant information. Cumulative impacts are considered in the EIA regulations and are critical information that ought to have been in the BAR and before the minister and the DG. We say in our heads also that, as far as we're aware, that environmental authorizations have now been granted for all 3 blocks with drilling plans in process. Exploration rights have been granted for block 1. So for those reasons, we consider the minister's decision and the DG's decision to be reviewable and stand to be set aside. The final ground under this portion of my address is that certain plans were required to be submitted after the environmental authorization was issued, and so they would not be required to undergo any measure of public participation. There are conditions of approval, which you'll find in paragraphs 5.5.6 and 5.5.7 of the EA, which require the holder to submit 2 further plans for approval. It's a shipboard oil pollution emergency plan and an emergency response and medical evacuation plan. However, given that these plans are to be submitted after the granting of the environmental authorization, as we say, they will not be subject to public participation. The documents that were subject to public participation, the BAR and the EMPR, did not include descriptions of the risks of the projects. The BAR failed to identify and include the risks, for example, of an oil spill emergency or other emergency incident, some of which could require emergency evacuation. It didn't propose mitigation measures in those paragraphs of the environmental authorization. So we submit that's a breach of Section 3.1H of Appendix 1 to the EIA regulations, which requires a BAR to include, amongst others, a description of the impacts and risks identified and how they can be managed, avoided, and mitigated. We also say the EMPR didn't include mitigation and management measures in those paragraphs of the environmental authorization, and that was a breach of Section 1.1D of Appendix 4 to the EIA regulations. So no public participation was conducted on these things at an earlier stage, and no public participation will be conducted on them post the issuing of the environmental authorization. The respondent's defense is that these plans are standard, that they're required by all maritime vessels, and that a public participation process is not required each time a vessel is permitted to sail. Now, our courts have dealt extensively with the requirement of public participation. I think this term the Constitutional Court has heard 4 cases on public participation. It's clearly a hotly contested subject. What is clear in our law is that public participation is not required on a whim. It's not required for every minor decision, and we don't suggest that should be the case. But what we do say is that these are significant reports that will be submitted after the environmental authorization. They're not standard reports we submit, and they will be outside of the scope of comment by the public. So this is not, it's true that under the Marine Pollution Act, there's certain plans that are required of ships. But in this case, these plans are required for purposes of an environmental authorization. So the fact that they have plans routinely submitted in relation to a different act is irrelevant to a consideration of whether they meet the requirements of the environmental statutes, which has heightened requirements, as we've seen throughout my address today. I'm afraid, again in Green Connection, this matter was raised. The High Court dealt with, found that Total could not lawfully be permitted to submit 2 plans. They were a blowout contingency plan and an oil spill contingency plan after the award of the EA, because they'd not be subject to public participation. And the court held that it's one of the foundational principles of NEMA that interested and affected parties must be promoted and provided a reasonable opportunity to influence the outcome of the decision at hand. I cannot see how that finding would be contested by my learned friends. But in that case, the fact that there was public participation in terms of a generic plan, the court held was not sufficient. So we submit that the submission of these further plans to a competent authority without regulations 40 and 41, and with the result that the environmental authorization and appeal decisions are reviewable on one or more of those grounds. Just deal with a couple of little issues that have arisen in the papers. The first is that one of the things that you will note in the papers is the allegation that this is an appeal dressed up as a review. And it's an allegation that mischaracterizes the review process and mischaracterizes the applicant's review grounds. First, it's not unusual that facts and arguments which were raised before a decision maker in an internal appeal find their way into review. That does not make this an appeal. In this case, those facts are used to show what relevant considerations, what information that ought to have served before a decision maker, for example, were not taken into account. It's not simply the position of our administrative law post-Paja is one that introduces a substantive notion of review. And Hoekstra says very clearly, it is very difficult to determine the fine line between appeal and review because of this. That is in line with the legislature's decision and our constitutional imperative to ensure fair administrative action in this broader sense. It's a substantive right. It is not as it was pre-Paja. So this allegation that where there are things that find its way into review that were mentioned in an internal appeal, that necessarily that means this is an appeal, misunderstands the context in which administrative law operates in our courts. This is not an appeal. This is very squarely a review. If one has pays attention to the grounds of review that I've been through this morning, virtually all of them are about a failure by a decision maker to follow a proper process. it is not a right or wrong answer. We come to court because what we consider the decision makers to have done in this case as being procedurally flawed. We do not seek a further appeal, and it is a red herring, I would submit, to ask this court to find that this is an appeal dressed up as a review. It is not. There are valid grounds of review that have been raised. The fact that there are similarities between this and the Green Connection case itself shows you that these are valid grounds of review that may be raised. And we submit there's no merit to that. Then, in relation to costs.
Sorry, in relation to?
Costs.
Are you going to deal with relief?
Yes, I can deal with relief now. My lady, you would have seen in our notice of motion that we asked for substitution. We've made it clear in our heads of argument that we no longer proceed with substitution. We asked for a finding by this court that the decision of the DG and of the minister are reviewed and set aside.
May I ask, what would be the effect of such an order? What would happen to the application?
To the application?
Not this application.
To the TGS application. Yes, that
I kept calling it the TFG application on Friday, and then I read, or the TGF, and then I realized why. In my own mind, sorry, yeah, after plowing through all of this, so yeah.
Fair
so
enough.
If I call it the T...
Set aside, the decision would no longer exist in law.
Yes.
Open to...
True. If the difference, which I would
My lady,
have
I would
thought,
submit...
got no power to tell just there is an application pending, that may cause a whole the reasons why I request for further information on Friday to understand what would then happen to the application. And I wondered if you could assist me on that. Substitution and remittal, yes. I get.
Yes.
But setting aside decision without setting aside application, I need some assistance on.
Yes. My lady, I will consider it and deal with it in reply. My submission at this point is that the relief that we seek is to review and set aside the decision. There are, it occurs to me, multiple things that could happen as a result of that, but I'll deal with it properly in reply. We no longer seek substitution. We accept that this is not an appropriate case for substitution. And we would imagine, we would hope, that the issues that have been raised genuinely and bona fide by the applicants in this case would be things that the department would wish to take into account in this and in other cases. On the issue of costs, my lady, the answering affidavit from the state respondents was delivered significantly late. It delayed things significantly, and there was a tender for costs that was made in relation to the answering affidavit. We have indicated in our heads that we accept that tender, of course, and that the cost of the answering affidavit for the state respondents should be borne by the state, or the cost of that delay. There's also a suggestion that the respondents would seek a costs order against us for various reasons. We would submit that this is not an appropriate case for a costs order to be made against the applicant. There is no reason for this court to depart from the Biowatch principle. The applicants have come to court in good faith, asserting substantive legal challenges to the impugned decisions. The fact that there are thousands of pages before this court is evidence of that. The fact that the departments have taken many of those 1,000 pages to respond to the legal grounds raised show that there is merit in them, and that there is, at a minimum, an important question for this court to adjudicate. In fuel retailers, the leading case on the question of balancing the need for sustainability, sustainable economic and social development, that case started in the High Court with 11 grounds of review. And by the time it ended in the Constitutional Court, and by the time the Constitutional Court made its decision, there was one ground of review remaining for consideration. The Constitutional Court saw nothing wrong with that, and we submit that that's because there is nothing wrong with that. That is the process. It demonstrates an applicant that is willing to consider the merits of its case and to be a responsible litigant, not unduly straining the resources of the court or their opponents. So, to the extent that we are criticized for abandoning 2 grounds, and today, if you add on the delegation points, 3 grounds out of 11, we would submit that that's not a basis for a cost order against us. It wasn't a basis in fuel retailers, and it's not a basis in this case. I've explained to the court that my clients are non-profit organizations and a community of small fishers. They come to court genuinely to assert their rights in the context of a decision that has significant impact on their livelihoods and their futures. For this court to make an adverse cost order against them, we submit would be unfair and unjust. My lady, those are my submissions. If there's anything else.
Nothing that I can think of now. Thank you very much.
Thank you.
Mr. Dupree.
May I beg leave to use my briefcase as a lectern?
You can use whatever you like. I really don't know.
Lady, the Scottish historian and novelist James Buchan said that a century ago petroleum, or as we call it oil, was just an obscure commodity. Today it is almost as vital to human existence as water. And this quote best illustrates the need to find and extract oil and natural gases in South Africa. The present crisis in the Hormuz Strait elevates this position. We can't argue against the need and desirability for oil and gas production in South Africa. But it's not only that, my lady. All of us came to court today at some time using vehicles that run on petroleum. The fibers in my shirt contain petroleum. The ink and the paper that I'm using contains petroleum. Agriculture, medicine, every aspect of life is influenced by petroleum. And then even more, the government's position is that natural gas must play a prominent role in the future of our energy plans, emphasizes the need and desirable. Now there's a plethora of statutes, regulations, policies of oil and gas. But fourth and the most important thing that was authorized, and we deal with that in paragraph 7 of our heads of argument. It is stated that seismic surveying is a precursor activity and is warranted or not. That any such future activity would require separate environmental authorizations and independent environmental assessment processes under the applicable statutory framework. Of our case mistakes that occurred in the original heads of argument, I don't know whether it was served on your lady by means of electronic form, but
I'm afraid I don't know the answer to that. But
Oh,
do they
lady-
differ substantially, or are
no,
they
my
simply
lady, it's only
typos?
some of the footnotes
Oh,
were
okay.
amended,
Okay.
and some grammar language and
Oh, okay.
certain minor phrases were adjusted, but it does not affect the gist of the arguments, and it does not affect it does not affect the numbering of the pages or the footnotes.
Mr. Dupre, maybe you could just take me to one example in the or the amended heads that you have, and I can see what I've got.
Okay.
Because I got a flurry of paper, and I think I took the most recent. Or the
My
most,
lady, this one was served yesterday afternoon, so then I'm quite sure the relationship will not.
I think our system was, and I quote, updating. It is still, and I quote, updating
Lady,
as of this morning. Yeah.
And to make it easy to find it, I've put it in that ugly blue
Thank you.
file.
Thank you. All right. Thank you.
Now, my lady, the matter, the proposed activity is confined to 3D seismic survey and does not include any provision for exploration drilling. No drilling whatsoever. What it entails is a vessel with acoustic equipment and 2 boats accompanying that vessel. And it is to be conducted in deep offshore waters between approximately 120 kilometers and 230 kilometers from the coastline, whilst the small-scale fishers operate in an area or radius of 15 kilometers from the coastline. So it's more than 100 kilometers from the area where the first applicant's members conduct their fishing. And it's also for a very, very limited period, only 70 days, including downtime. There will be no rehabilitation necessary afterwards, and as we'll explain later, there are mitigating measures in place to ensure that the damage to the environment will be limited to the minimum. And this aspect is significant because, having regard to the substantial distance between the survey area and the area coastline, it exposes the fallacy of the application that these 65 members of a co-op who see themselves as the whole community, whole livelihood is threatened by this seismic survey. My lady, I said 15 kilometers, it is 15 nautical miles, but that equals 27.8 kilometers. Now, my lady, the DG's 23 and the Minister's internal appeal decision is dated 22 May 2024, a year later. Now, this appeal was legislation. Some of the statutory provisions that the respondents rely on, if I may say respondents, I refer to the first, second and third, which requires the state while also promoting sustainable development and socio-economic is not prohibited. NEMA, Section 2, sets out the environmental management principles, includes decision makers to integrate proportionally so that the present needs are met without compromising the ability of future generations to meet these. Lady, the present need is for oil and gas. Now, Section 24 of NEMA provides a framework for the EI. And it sets the minimum requirements for the procedures for investigation, assessment and communication and consultation. That's Section 24.4 of NEMA. Section 24 capital Q sets out the monitoring and performance assessment requirement. Chapter 5 of NEMA and the regulation provides for the control of different authorizations. And capital B requires survey, requires such a reconnaissance permit. And to be granted a reconnaissance permit, you must have a basic assessment as well as a basic assessment report, and it is not necessary to submit a scoping or detailed report. Environmental impacts are well understood. Points in respect of these type of environmental authorities, whilst the Section 43.1 capital A appoints the second respondent as the appeal authority. Now, this came about due to the one environmental system. That's an agreement between the different departments how to manage this act, and subsequently there were statutory amendments to give effect thereto. And each one has now its own defined role to play in the whole process. Now, my lady, Section 1 of the NPRDA carried out for or in connection with the search for a mineral or petroleum by geological, geophysical and photogeological surveys, includes any remote sensing techniques, but importantly, it does not include any prospecting or exploration operation other than acquisition and processing of new seismic data. Nothing else than seismic data. And this is a process that has been used for many years without any real detrimental effect. No reported effect. There may be gaps in knowledge which will be closed as the research goes on, but the applicants are unable to show one instance where seismic surveys caused any huge or permanent damage to the environment. And then reconnaissance permit is defined as a permit issued in terms of section 75(1). Now, my lady, no reconnaissance permit may be issued without an environmental authorization, and the permit holder is to undertake geological, geophysical, or photographic surveys and other remote sensing techniques. But what is important, and we must make it clear, my learned friend referred to a exploration permit, that it's valid for 3 years and may be renewed for a further 3 times thereafter. A reconnaissance permit is valid for 1 year only. Now, in the sense that she argued that it may lead to further permits that may be extended, at this stage, no one knows whether there will be a further permit. It depends on what is going to be found by the survey. If there's nothing, there will be no further permits issued. If something is found, then there must be a new process, a new application for an EA for that specific activity that will cause an investigation, assessment, reports, and a new consideration. What is important, my lady, is that PASA is the statutory appointed state of organ that accepts, handles, and advises the MPRDA and NEMO are intertwined. My lady, there was reference to the Green Connection decision of this division, which is on appeal. Your ladyship may be alive to the fact that in March there was a similar application argued before the full bench of this division.
That was for exploration drilling.
Yes, my lady, but the issue...
Oh, no, maybe that was 2 weeks ago. I'm getting a bit confused.
No, my lady, it was...
was it in March?
It was in March, my lady.
I believe it's already June. Okay.
Time flies.
But that is the one you're talking about,
yes,
in front
lady.
of Judge Sher and 2 colleagues. Okay.
That's correct, my lady.
That's all I know. I know nothing else
Yes.
about it. Yeah.
My lady, but what is important is that most of the arguments raised in respect of the reconnaissance permit was raised in respect of the exploration drilling. And the issues as far as PASA's authority, etc., the need and desirability criteria, they were all considered and argued in that case. And that may complicate the ladyship's position even further than the Green Connection bill. But lady, I'm going to start now with a new subject, but I see it's 5 minutes before lunchtime. Will it be a convenient time?
It would. Thank you.
you.
Thank you very much for the hard copies. We have a few difficulties in accessing things on our server at the moment.
Thank you.
We'll adjourn until 2:15.
Thank you.
Hello? Cool.
Thank you, Melody. Before the adjournment, we dealt with the one environmental system and the fact that there was an agreement between the mineral department and the environmental department. And this system serves as a check and balances between the two departments. Where the one wants to extract minerals, the other one wants to protect the environment. And that the third edition at page 213, the last sentence on that page says that judicial review is largely incapable of giving the applicant what he or she really wants, a substantively favorable decision. But then importantly, conversely, review conceived as an appeal poses a threat to democracy because it gives judges an opportunity to usurp the functions entrusted by the legislature to the administration. Judicial review is essentially a reactive or backward-looking safeguard. And this is reaffirmed at page 424, but I'm not going to read that into the record. In the South Durban Community Environment case, the ECA emphasized that review grounds must be distinct from and not merely repetitive of the grounds advanced in the internal appeal. Your Ladyship will find the reference in footnote 14 on page 18 of our heads of argument. And an applicant or a litigant cannot simply restate appeal grounds in the language of a review. And if one has regard to the language in the founding papers, my lady, this is nothing else than a disguised appeal. It's not a review. The applicants invite your Ladyship to re-evaluate the substantive correctness of decisions, to re-weigh the need and desirability assessment, to expand the scope of the inquiry to include exploration and production of gas and the full life cycle ecological and climate impacts, and to reassess the acceptability of the socio-economic consequences for fisheries and coastal communities. And we submit that you should approach this on the basis set out in the constitutional judgment of Baberi Murata Umane, and the reference appears in footnote 17 of our heads of argument at page 20. The Constitutional Court said, our right is just administrative action and paja. The legislation enacted to give effect to that right require rigorous scrutiny of administrative decisions. But neither ask courts to substitute their opinions for those of administrative bodies. It is not required that the decision of an administrative body be perfect, or in the court's estimation, the best decision on the facts. And this is particularly so for rationality review and paja. Hoekstra notes that a crucial feature of rational review and paja is that it demands merely a rational connection, not perfect or ideal rationality. In a different context, Davis J. has described a rational connection test of this sort as relatively differential, because it calls for rationality and justification rather than the substitution of the court's opinion for that of the tribunal on the basis that it finds the decision substantively incorrect. And then a level of deference is necessary, and this is especially the case where matters fall within the special expertise of a particular decision-making body. We should, at this court, counselled in Batustar, treat the decisions of administrative bodies with appropriate respect and give due weight to findings of fact made by those whose special expertise and experience. My lady cannot resent that administrative decision like the current one is one that is not based on these requirements and these qualities. The fact that there are differences in opinion, including the environmental impacts, the acoustic effects and mitigation, shows that there are disputes of fact. And that is not something that's a review, administrative action being reviewed. That clearly shows a dispute on the merits, an appeal disguised as a review application. And my lady, we submit that the application can be dismissed on this basis alone. And I'll argue the cost aspect later on. My lady, in our heads of argument, we followed the sequence of the grounds of review. What I'll try to do in my argument is to follow the argument of my learned friend for the applicants. And I will start with the failure to consider an EI, which is in our heads of argument the 9th ground of review. Now, this ground is premised on the DG's alleged failure to consider the BAR, specialist reports, the MPR, and the comments by interested and affected parties. Now, the Rule 53 record shows that only one document was before, or that the only document before the DG was the application form with appendices. Therefore, the DG did not consider them. That is the allegation. And that the PASA officials drafted the environmental authorization. Now, my lady, we submit that this ground is premised on an incorrect characterization of Rule 53 record and the EA itself. If one has regard to the EA, and I'll deal with that instantly, it shows that the DG did consider all these documents. Now, lady, the respondents were criticized because there's only a confirmatory affidavit by the DG. And the fact that he did not clearly set out which documents he considered. But if one has regard to paragraph 1.6 of the minister's affidavit, which appears at page 4026, 4026. Page 4026. Paragraph 1.6. The DMPR DG, in a confirmatory answering affidavit, confirms the allegations in this answering affidavit insofar as they pertain to him and the EA decision, and sets out the broader framework, additional aspects considered by the DMPR, and elaborates on other relevant considerations in the issuing of the EA decision. Ladies, similarly, in paragraph 67 of the minister's affidavit at page 4303, page 4303. In paragraph 67.1 under section A, and in particular the 9th ground of review, it is alleged that the DMPR DG did not consider the BIR specialist report, etc. 67.2, a plain reading of the EA demonstrates that the allegation is misconceived. A full and fair reading of the EA and the accompanying record of decision demonstrates that the DMPR DG considered the BIR and the other documents. The EA expressly records that the authorization is granted to undertake the listed activities as described in the BIR EMP submitted on 6 September 2022. And then it further states that the DG is satisfied with the information made available, and several references are made to the BIR EMPRE. And it continues. I'm not going to refer to each and every allegation. But at page 3997, paragraph 2.4, that is the affidavit of the DG. The DG does not only oppose to a confirmatory affidavit. In that paragraph, he expressly states, I therefore repeat and incorporate the contents of the second respondent's answering affidavit. In other words, everything stated in the minister's answering affidavit. And then importantly, and confirms the correctness insofar as it refers and pertains to the DMPRE, me, and my decision of 17 April 2023. So the DG cannot be criticized that he did not depose to an affidavit that contained all the allegations set out in the minister's affidavit. S5, which appears at page 2494 of this, and it's annexed to the supplementary affidavit. This is the index compiled by the applicants of the record. And the applicant's whole argument is premised on the absence of certain documentation. And lady, if one reads the documentation, it is dated September, October, documents that follow immediately thereafter. But in the environmental authorization, the DG referred to all the documentation. If one looks at page 193, and this is the Annex A3, or I beg your pardon, A2. It reflects the signature of the DG. Then at page 195, there's a heading activity authorized. Relationship will notice it reads, by virtue of the powers conferred on it by the National Environmental Management Act and the Environmental Impact Assessment Regulations, the Department hereby grants authorization to TGS Geophysical Company Unlimited to undertake NEMA EIA listed activities specified in section 3 below as described in the BAR, VAR or EMPRT submitted on 6 December 2022. Now the question is, how did the DG know of this BIR, EMPR of 6 September 2022 if it was not before him? At page 197, says that the holder of this authorization is authorized to conduct the following activities within the area described under section 4 below. And then there is a whole list of activities with specific details that appear from the BIR. The lady at page 209, paragraph 5.4.1. The
Sorry, paragraph?
5.4.1,
Did you say 209?
209.
I don't have a 5.4.1.
Milady, there are two numberings. It's a red number. Oh,
I only have one.
I beg your pardon. It's, the printing is not good. It's 200.
200.
I
Yes, because
apologize.
that's the appeal decision, yeah. Okay, thank you.
Paragraph 5.4.1 page.
Thank you, I have it.
The bar EMPR is hereby approved. It's hence mandatory for the holder to implement all the recommendations and management measures stipulated in the EMPR throughout all phases of the proposed activities. Now, once again, if that document was not before the DG, how could it have been incorporated in the EA? At page 202, paragraphs 5.5.10, maintain a pre-acquisition watch of 60 minutes before any instance of seismic source testing to confirm that there are no penguins or feeding aggregations or of diving seabirds, schooling large pelagic fish, turtles, seals, etc. And then in the last sentence, as defined in the approved BIR EMPR, if only a single lowest power seismic source is tested, the pre-acquisition watch period can be reduced to 30 minutes. Once again, a reference to the BIR and the EMPR. At paragraph 5.5.15, that will deal with another aspect. And then 5.5.16, it's the next one. As recommended, mitigation measures included in the BIR EMPR dated 6 December 2022 are deemed to be conditions of this authorization and must therefore be adhered to, obliging TGS to comply with the bar. And then, my lady, at page 204, the DG says all the information presented to the department was considered in making this decision. The said information includes, among others, and I'm not going to read everything, my lady, but in paragraph 1.3, there's a reference to the BIR EMPR. In paragraph, and then there is also reference to specialist reports in 1.4, and they are listed. In paragraph 1.5, there's another reference to the BIR EMPR. And then paragraph 2, heading submissions and considerations of the basic assessment report and environment management program. And then there's a whole discussion on that aspect. Now, my lady, we all know what the Helen Suzman matter said, but what is important is whether it can be cured. Now, what the applicants are doing is that they are placing form above substance. The fact that a Rule 53 record does not contain certain documents, whilst there are clear references to the documents in the decision, cannot nullify the decision. There's a problem with the record. Now, we are confronted with the record as it stands. I can't tell you why those documents do not appear there, but that can, such a minor defect can never nullify the decision. In any event, the record does contain those documents, albeit not under the name of the DG. And the minister considered everything under a wide appeal. Considered all these documents. And apart from certain conditions that were inserted, agreed with the DG. And my lady, the DG, having regard to the affidavits as formulated, clearly states that he did have regard to these documents. So, my lady, under those circumstances, we submit there is absolutely no merit in this ground of review, and it should be dismissed with an appropriate cost order. In argument is the PASA argument, which is the 10th ground of review in our heads of argument, lawfully considered by the minister. Now, my lady, it is common cause that PASA, as an organ of state and interested party, is entitled to make, particularly if one has regard to the regulations. There is no obligation on the minister, on the DG, or any other part to submit, if any. My learned engineer informs me I must inform your lordship that my lady, if one has regard to the supplementary affidavit, page this is once again the index prepared, but at page,
Hang on, 2940. I've
Yes.
got 3 different numbers. On the left, I've got 2385, then I've got 2940.
But,
Might be, maybe it's,
my lady, if I don't know whether you have. You,
mine says grounds of appeal. Look,
at my papers, there are in red a numbering. I don't know whether you have, and it's a top numbering,
no. I've got,
and it's a bold numbering, lady. Well, lady, are we on the same page? I'm busy with the supplementary affidavit.
I've got the supplementary affidavit starts here, but then it carries on to page, according to what I could work out, page 3281.
Lady,
I tell you what, I'm just going to ask,
okay.
see where we are. Thank
My
you.
lady,
No, don't worry, it's fine.
I'm only referring to the index prepared by the applicants, and then I'm going to move to. Yeah,
2494 then,
lady, the
JWS5.
correct numbering, as I look at this document, is at the top.
Right
of
in the top
yeah,
right-hand
yes.
corner. Okay, thank you.
But my lady, maybe we should. Yeah.
So are we talking about JWS5?
Like now,
Yes.
Okay,
yes.
that's the index.
That's the index.
Okay,
prepared.
just bear with me a moment. Thank you.
Yes, that's what it
Thanks.
296.
So you want me to go to JWS5?
Yeah, my lady, maybe we can skip that and go to page 2969. And that is.
That's the signature page.
Yes, we
Okay.
Now, this is the document signed by the PASA representative. And what is important is the ARR comments by case officer at the top of that signature. So he identifies himself as a case officer. Lady, then this document starts at page 2952.
JSW9.
That's correct, my lady.
Okay.
And Your Worship will see appeal response report. There's a reference to the project name title, project location, project reference number PASA, and then the date of the project, and then the date of notification. Now, if one turns to page 2954, this is where the comments start, my lady. Now, my lady, the process is that the applicant starts with the first column to complete that. Then you have the responding statement by the applicant, and then, although it's the heading comments by the department, my lady, any party can use that column to make comments, or by means of another document. But what is important, it is comments by the department, not by the DG. And PASA is part and parcel of the department. It's a statutory created part of the and the opening words of the comments process, PPP, and the taken was in line with the view expressed. And this was signed off at page 2969, subsequent to the DG's decision. Once again, the applicants are putting form above substance. If PASA made these recommendations in or submissions in a separate document, would they have had a problem with it? But because they used that specific document, now suddenly, decision of this importance, decision of this magnitude, decision that might have implications for the benefit of the whole of South Africa, must be set aside. Lady, and regulation 4.2 of the environment requires an applicant to use this form. Yeah. And that is the appeal regulations, lady. And then, my lady, lastly, how could this have influenced the minister in not making an objective, independent, wide appeal decision? The fact that the submissions were made in a column to a regulatory prescribed document. And we submit, my lady, that under those circumstances, there is also no merit in this round of review. It stands to be dismissed with costs. The third point is the ICMAR aspect, which is our fifth ground of review in the heads of argument. And as I understand it, is based on the DG and the Minister's failure to consider and apply ICMA, especially sections 12 and 63. They say because the exclusive economic zone, the activity is a coastal activity, because it falls within that exclusive economic zone, they must have considered the factors mentioned in section 63. Now, a lady will find the wording of section 63 of ICMA at page 122 of our heads of argument. Paragraph 3.18. As I understand it, according to the argument, emphasis was put on subsection C, where the coastal public property, the coastal protection zone, or coastal access land will be affected, and if so, the extent to which the proposed development or activity is consistent with the purpose for establishing and protecting those areas. Now, there is no evidence whatsoever that any of these coastal properties would be affected, and then under the whole community. And once again, my lady, we sit with a co-op with 65 members. And my lady, classifies offshore reconnaissance or exploration. I'm a lady. Makes reference to ICMA as one of the additional South African statutes or legislation that may be relevant. But Appendix 1 of the EIA regulations does not require a statute by statute exposition of every applicable legislative provision. And it is not necessary to address each provision of Section 63 of ICMA, because in many instances it overlaps with the considerations ordinarily associated with the NEMA EIA. This aspect, and the minister considered the complaint and rejected it. Under a wide appeal, hearing it de novo. The real complaint here is about the reasoning of the minister and not non-compliance. And the EAI and the NEMA satisfied substantive requirements under section 12 and 63 of ICMA. And the lady in the Kawabe constitutional case matter, paragraph 63, the Constitutional Court said that it does not have to show every aspect in minute detail. In paragraph 65, the Constitutional Court said when Ms. Franke informed the applicants of the invalidity of their permanently resident, I beg your ladyship's pardon, paragraph 63, I started with 65. Although the reasons must be sufficient, they need not be specified in minute detail, nor is it necessary to show how every relevant fact weighed in the ultimate finding. What constitutes adequate reasons will therefore vary depending on the circumstances of the particular case. Ordinarily, reasons will be adequate if a complaint can make out a reasonable substantial case for a ministerial review or an appeal. So, my lady, under those circumstances, the applicants do not establish a reviewable irregularity, and the application stands to be dismissed on that basis. May I quickly take this up? The lady, what is important to understand is that this whole project falls in the whole coastal area. It is in the sea, covers the whole area. It's not limited to a specific area where a specific community or area may be influenced or affected. I'd like to put it a bit more clearer. Though the project is limited to a specific area, the whole activity falls in the sea.
Understand that.
Now, as we understand the fourth point, the need and desirability, which is our third ground of review, pertains to three interrelated complaints. One, the BAR only assessed the positive impacts of future oil and gas production for need and desired purposes and not the negative ones. Two, the no-go alternative was not properly assessed. And three, the potential social, economic and environmental impacts of future exploration and production were not assessed. Now, once again, my lady, we submit there is no merit because this is an appeal disguised as the review, and the court cannot replace the competent authority's assessment with its own. Now, the BAR addressed need and desirability in view of all the regulations, guidelines, policies, and the no-go was specifically addressed in the BAR and considered by the DG and the Minister. And first of all, to consider a reconnaissance application entails different considerations than for exploration or production. And you cannot look into the future when you make a decision regarding reconnaissance and establish what the negative effects may be. The fact that there is a statement that there is a positive effect doesn't mean that that was considered and made the begin and all of everything. Lady, this activity has no climate change impacts whatsoever, and 70% of the area that TGS wants to survey has not been surveyed yet. The Searcher Geodata survey was for a much smaller portion, and in any event, as I understand it, lapse. Now, Regulation 18 of the EAI regulations requires a need and desirability assessment and restates the requirements under Section 24.4 of NEMA. Now, my lady, the need and desirability guideline is not binding legislation, but policy. It requires a consideration of the development proposal along with the broader societal needs and the public interest, provides that consistent with national priorities, environmental authorities must support increased economic growth and promote social inclusion, whilst ensuring that such growth is ecologically sustainable. And then in the fuel retailers case, the Constitutional Court stated what NEMA requires in respect of the need and desirability requirement, and that appears at page 89, paragraph 239 of our heads of argument. The Constitutional Court made it clear that NEMA requires that the best interest of the environment be balanced with socio-economic interests. Thus, when area development which may have a significant impact on the environment is planned, it envisages that there will always be a need to weigh considerations of development as underpinned by the right to socio-economic development against environmental considerations as underpinned by the right to environmental protection. In this sense, it contemplates that environmental decisions will achieve a balance between the environmental and socio-economic development considerations, though not through the concept of sustainable development. Now, my lady, the BAR deals with the need and desirability requirement, and that appears at page 293.
Sorry, just bear with me a moment.
Page 293, paragraph 5, need and desirability of the proposed activity. And then in paragraph 5.1, it refers to the guideline on need and desirability in terms of the EAI regulations. At page 294 and further, there is a question and answer aspect. At page 305, paragraph 5.2, there's a specific heading, need for seismic data. In addition to the information presented in table 6 above, discussion of the need and desirability of the project would not be complete without understanding the need for acquisition of the seismic data and possible oil and gas exploration and production that could potentially take place in the future as a result of the survey. Importantly, my lady, potentially take place. It cannot be said that with absolutely not currently possible to accurately assess the risk associated with these activities, given that the specific details of these potential future activities are not known. Current application and would need to be assessed in detail during the subsequent scoping and EIA processes, should exploration, drilling or production be proposed. The environmental. And my lady, we submit that's the end of my lady, sorry. Lady, here I also discussed the no-go alternative, which is the principle of not implementing the activity at all. At page 508, paragraph 9.3.6, the no-go alternative is the heading. The no-go alternative would imply that no survey activities are undertaken, and as such, the negative impacts as stated above would not materialize. However, conversely, this will negate the potential positive impacts associated with the proposed activities, including the opportunity to identify potential oil and gas resources within the application area, including potential future contributions to the economy of South Africa. The opportunity, because there is a gap as far as this is concerned presently, and provision of job or training opportunities very limited during the survey phase. Remember, it's only for 70 days during, including downtime. Since there are no mitigation measures, the impact significance will be low, pre and post mitigation, and final significance will be the same. And this was considered by the Minister Paragraph 2.21.3.
Sorry, may I have that reference again?
It is page 241,
Yes.
paragraph 2.21.3.
Thank you.
Lady and the Minister said, I've considered the needs and desirability of the project. The BAR on page 21 to 23 thereof addressed the needs and desirability of the project and further covers the context of the oil and gas industry, applicable policies and planning frameworks, local, national and international, and broadly societal needs and public interest. I note that the project is aligned with government policies and plans such as Seismic to meet the country's electricity recovery alternative, which is also addressed on page 36 of the file for the project has been demonstrated. Now, my lady, I've I didn't extract from these pages, but you may read pages 241 and 242 as they are. Therefore, my lady, we submit that under these circumstances there is absolutely no merit in this review ground. Once again, it is dissatisfaction with the merits of the case, how the Minister exercised her discretion at this time, and not with an irregularity that deserves attention.
So, Mr. Dupree, using my own words, your argument is you can't assess whether something is going to have a negative impact if you don't know what it is.
Yes, lady. And what the extent thereof will be. Yeah, and my lady, in any event, you don't know whether it's going to happen, whether you are going to find anything.
That's really what I'm saying as well,
Yes.
because it's, as on your argument, it's an unknown. You don't know whether you're going
It's
to.
an unknown, and you can't assess an unknown. My lady, the next ground is
May I just have a follow-up question?
Yes.
Just based on what Ms. Rajab Badlander submitted this morning, that it's one has to take potential negative consequences or impacts into account, using my own words. Can you conceive of any that should have been considered? In other words, something that wasn't unknown or potentially unknown. Of how these.
Yes. I'm not aware of any such possibilities. Look, one may argue that there may be a blowout, but that is when you have actual drilling. And there's
But in terms of this particular activity.
this particular, no, my lady, you can't say.
And there's no evidence that there is a negative in terms of what was before the
Minister or
the DG and the Minister.
No.
Okay. Thank you.
My lady, the next ground, it's our sixth ground of review, the defective EMPR. Lady, as I understand this ground, it is premised on the fact that the MPR allegedly fails to comply with Appendix 4 of the 2014 EAI regulations because it does not identify impacts and risks, and it does not set out adequate mitigation, monitoring and management measures. Now, Section 24 of there is not a rigid form prescribed or a narrative structure. Neither does the RIE regulations, or do the regulations deal with this aspect. It only deals with the content. And we submit that it is not necessary to deal with the MPR content separately if it under a separate heading, if it is already contained in the MPR or in the bar. The MPR is not a standalone document and does not repeat the BAR that for which considered them. Its purpose is to convert the mitigations identified in the BAR and specialist studies into practical and enforceable management actions. And we submit that there were substantive compliance. If one looks at Section 11D of Appendix 4, it requires a description of the impact management outcomes and identifying the impacts and risks that need to be managed. My lady, if one looks at RI 14 at page 4700,
Four double 70.
4700.
Oh, I thought I'm missing a 5. Oh, yes.
Lady, what the applicants want is further consultation, workshops, learning, etc. If you analyze what the essence of the complaint is, now, my lady, this was considered by the Minister. At page 242. Lady, page 242, paragraph 2.21.8. The Minister said, I'm concerned about the plight of small-scale fishers and the communities that they belong to. I appreciate the project presents a cause of concern and anxiety for small-scale fishers and communities for whom the well-being of the sea, fish stocks and environment is crucial to their own physical and emotional well-being. Next paragraph. While I'm satisfied that communities were consulted and that their concerns were taken into account, I nevertheless take the view that the applicant needs to do more on an ongoing basis to allay their fears and anxiety. This can be done if the communities have an open channel of communication with the applicant. Thus, if they have some concerns that arise from, for example, that's on the next page, things that they may see or hear about that worry them or cause them anxiety, they should be able to raise these with the applicant, and the applicant should spend time investigating the source of the fears and anxiety and to allay them or to otherwise address them. For that reason, I'm including a new condition in the EA requiring the applicant to appoint a community fisheries liaison officer who must be available to the affected communities. The communities must have access to the liaison officer, who in turn must keep them informed of the activities at regular intervals and be available to answer any question that they may have. This will go a long way to allaying fears and anxiety. This is separate from the grievance procedure. So, my lady, the Minister was aware that there are anxieties, appointed a liaison officer, and these aspects may be raised with that person. It's not necessary to set aside a decision of this magnitude purely on the basis that the community have anxieties about consultations, workshops, further learnings. And, my lady, the grievance procedure is set out in paragraph 5.5.15 of the EA at page 202. So, my lady, we submit that this is also review ground with any merit. It stands to be dismissed.
So you said page 202.
202. 5.5.15.
It's not the actual grievance mechanism, though. It simply says that one must.
Yeah. But
Community engagement protocol, which must include a community strategy and grievance mechanism. It doesn't say what the grievance mechanism is.
yeah, but that must be developed. Lady, the next ground is our first ground of review, the marine impacts. Lady, we are, as I understand it, it's based on 4 primary allegations. namely that the BAR omitted relevant information and considerations regarding the impact on marine life. 2, that the DG Minister's decisions were not rationally connected to the info before them. 3, that the decisions were irrational and or unreasonable. 3, the DG Minister failed to give adequate consideration to the precautionary principle. And then, lady, we are confronted with a plethora of unsubstantial allegations and generalizations in the founding affidavit that we had to meet. But we submit that the core complaint is that the DG ought to have refused the EA and that the Minister ought to have upheld their internal appeal for 4 reasons. 1, there are critical gaps in knowledge arising from the scope and assumptions of the acoustic marine studies. 2, the DG Minister failed to consider expert evidence submitted by the applicant. 3, inadequate mitigation measures. And 4, failed to apply the precautionary principle. But we submit that the applicants conflate 3 separate inquiries. The first one is rationality. The question is whether there is a rational or logical connection between the decision and the purpose or end thereof. That is the pharmaceutical manufacturer's case as well as Eloff's article that appears in footnote 30 of our heads of argument. Secondly, reasonableness, whether the decision is one that a reasonable decision maker could not reach. And then thirdly, the merits. The question is whether the decision is right or wrong, and is an appeal, not a review. And we submit that this is exactly where the first ground of review fails, because it's once again disguised appeal. And the critical gaps, lady, is discussed in the BAR. The BAR is a comprehensive document. Which dealt with a lot of aspects and information. For example, the noise impacts, and it's done at page 506 to 508. Ladyship will see at the bottom of page 506, paragraph 9.5.3, cumulative noise impacts associated with multiple surveys. And it continues up to page 508, paragraph 9.3.6, no-go alternative. Now, my lady, the Minister considered these aspects in paragraph 2.5.5 to 2.5.17 in the appeal decision. And paragraph 2.5 is at page 219, where under the heading cumulative noise impacts. Continues on the next page, and then you have at page 221 heading noise acoustic. Continues on page 222 until page 223. Lady, the BIR contains a section on impacts on marine ecology at page 470. Page 470, paragraph 9.3.1. And it deals in paragraph 3.9.1.1 with acoustic impacts of seismic surveys on marine fauna. On the next page, paragraph 9.3.1.1.1 with noise impacts on whales and dolphins. Next page, noise impacts on seals. And the lady continues, even at page 477, there's other impacts of seismic surveys on marine fauna. And this was considered by the Minister at pages 234 to 235, at paragraphs 2.11 to 2.14. In paragraph 2.11.1 on page 234, the Minister said, the impact of the third appellant raised the following grounds of appeal: the impact of the 2D and 3D seismic surveys and the sound impulses and multiple hydrophone streamers on the marine animals and environment is significantly high and detrimental to their well-being. And then she listed the reasons what the applicants alleged. And then in paragraph 2.11.2, the following is said: detailed impacts of seismic surveying are still unknown and more research is required. Continuing, and then she deals in paragraph 2.12 with the applicant's response, and in paragraph 2.14 on page 235, the evaluation reasons for decision. The third applicant's appeal is concerned with the impact of seismic pulses on marine mammals. This aspect has been addressed in detail in the preceding appeals, and I refer to my comments in relation thereto. Accordingly, there is no merit to this ground of appeal and is dismissed. So, my lady, this is an aspect which the applicants repeat time after time after time. It has been dealt with in so many instances.
In other matters.
In other matters. Milady, then there was also a fisheries impact assessment. It appears at page 375 up to 426, paragraph 8.5.
Sorry, paragraph?
8.5. Lady, I'm not going to take it, but if one has regard to that, there's a detailed assessment of the fisheries, the impact that the activity will have on the fisheries industry.
And is that in the minister's decision?
As well, my lady, it is page 231.
In the BAR?
Of the appeal decision.
Oh, okay.
Paragraph 2.10.11.
And if you could give me the reference in the BAR?
Milady, it is paragraph 8.5, pages 375 to 426.
Oh, sorry, is that the BAR?
Yeah, that's a BAR.
I'm getting myself confused. And then the minister's decision
Yeah.
would be?
Page 231, paragraph 2.10.
Sorry, thank you. Mr. Dupré, would it be possible for us to adjourn? I've just got to think of the court staff, and it's 4:45.
Milady, it's a very convenient time. Thank you.
That's all right with everybody else as well? Thank you. All right. Then we are, if you just bear with me a moment, I just need to get my filing system sorted. I'll find everything again tomorrow. There. Thank you. Then we're adjourned until 10 tomorrow morning.
Esengihamba ngokudlozela ngoku. Ngokuyidlozela. Yo. Yo.
Dis nie langer as 2 wees.